Flashing someone or exposing yourself in public. Indecent exposure. We all think at first glance we know what that means, but the law's a little bit different in California. In this video, we're going to talk about what is and what is not indecent exposure under Penal Code Section 314 in California. And we're going to talk about the other lesser offenses, something like lewd conduct in public, what the penalties could be for that compared to indecent exposure, including but not limited to jail time, including but not limited to the differences whether someone will have to register as a sex offender in California, and if so, for how long. What you may think is indecent exposure may be wrong, it may be inappropriate, it may be outright disgusting. But if the elements don't match to what the law in California says, you have a viable defense to this serious charge and could hopefully avoid many of the most serious consequences. Let's get into it. In order to really understand what indecent exposure is in California and what it is not, let's look at the elements. The first thing is you need to actually expose a genital in a public place or in a private place where people may be there and they may reasonably be offended. Okay, sounds pretty simple. You're exposed, someone's there, they could be offended. This will include things like potentially public urination. This can include things like streaking. This can include things like two people being intimate in public. But there's another component to indecent exposure that really differentiates it from what people may think is indecent exposure and what indecent exposure may be defined in other states. And that is it for the purpose of gratifying the lust of either yourself or of someone else, their sexual desires or the sexual desires of yourself. So that component, that last element of for the purpose of satisfying the sexual gratification of yourself or for others who could potentially see it, is where there are many defenses which we'll explore in this video to California indecent exposure under Penal Code Section 314. There are some penalties and possible sentencing outcomes if you're convicted of indecent exposure in California. Well, without any prior criminal convictions related to this, it is a first-time offense as a misdemeanor, where you can be punishable in jail up to several months and a fine of up to $1,000 with some penalty assessments and so on. But the biggest issue a lot of people face when convicted or even when charged with indecent exposure is what comes as a result of a conviction. I'm talking about mandatory sex offender registration under Penal Code Section 290. For the longest time in California, if you're convicted of a sex offender registrable offense as a misdemeanor or the most serious felonies, you would have to register for the rest of your life, long after any jail sentence or prison sentence has been served, long after any probation or parole period has expired. Well, the law changed in California, and now what we're dealing with is a tiered system. So there's tier 1, there's tier 2, and there are tier 3 offenses as it relates to sex offender registration. Tier 3 is the old school sex offender registry. It's for life. You have to register for a day because of it. It's for the rest of your life. Tier 2 says that after 20 years having registered, with some exceptions and some ways that can extend it, you could go back before a judge and petition to have that obligation, that burden, relieved, so you no longer have to register. And Tier 1 offenses, which is where indecent exposure falls, says that after 10 years of registering, you can ask the court to relieve you of that obligation, but that is discretionary. So just like it was back in the day, you're convicted of indecent exposure, you have to mentally be prepared to, for the rest of your life, have to register as a sex offender. You might be able to get rid of that obligation after 10 years, but there's no guarantee. The sex offender registration, far more than time in jail, far more than any fines, is the biggest thing you are trying to avoid if charged, because once you're convicted, it is mandatory. Now, we first started talking about this penalty clip, talking about how, well, it's only a misdemeanor for indecent exposure. But if you have multiple priors for indecent exposure, this new one could be bumped to a felony. You could be subjected to state prison, and arguably your sex offender obligations, registration obligations, and arguably your obligations could be increased if you were charged as a felony or with other offenses. So the first time is a misdemeanor. After that, it could be bumped up and go higher and higher. But the key component, whether as a misdemeanor or as a felony, what you're trying to avoid, whether it's to beat the case outright or to try and negotiate to a lesser offense, is to avoid the mandatory sex offender registration, whether you wind up getting off the registry in 10 years, years, 15 years, 20 years, or whether you're subjected to it for the rest of your life. Let's talk about some next steps and possible defenses if you're charged with or even just under investigation for committing indecent exposure in California. Well, the first step is if you're under investigation, the same rules apply no matter what you're under investigation for. You're not going to want to make voluntary statements to law enforcement or to your accuser. You want to be careful for something known as a controlled call or a pretext call, where someone calls you and says, hey, why'd you do that? Why'd you make me feel that way? And then you're apologizing, and that's recorded and going right over to the police and to the prosecutor. You also, if you're confronted by law enforcement, you don't want to start firing out alibi defenses and start saying, well, no, I was here, I was in this area, because how do you know the cops are telling you the truth? Imagine a situation where you're living in downtown San Diego, you're spending the day in downtown San Diego, you get pulled over in downtown San Diego, and the cop says, hey, we want to investigate you for an indecent exposure that happened in Carlsbad. You start blurting out right away, I've been downtown the whole day in the East Village in downtown. How do you know the cops are honest that the investigation really was in Carlsbad? How do you know you just didn't put yourself at the scene of this indecent exposure? How do you protect against it? Keep your mouth closed. Politely decline to answer any questions. Don't confirm where you were, who you were with, what if anything you were doing, and why if any way or any reason why you were in fact doing what you were accused of doing. Get a lawyer, have an opportunity to speak to that quality criminal defense attorney you hire, and prepare your defense and your strategies accordingly. Now let's say it's too late to talk about, well, I wish I had that information when I was talking to the cops, but now I'm charged. What are some defenses? They still need to prove identity beyond a reasonable doubt. They still need to prove that you were exposed beyond a reasonable doubt. They still need to prove that you were exposed in public or in a private area where people would reasonably see you exposed beyond a reasonable doubt. And most importantly, they still need to prove that you did something to direct attention to your genitalia or your exposed region for the sexual gratification of either yourself or the other people to see it. And that too needs to be proven beyond a reasonable doubt. Sometimes you could be harmlessly urinating in public. Not a great decision, but sometimes it happens. Doesn't mean you're guilty of indecent exposure. There are a lot of defenses, but the key, like with anything, is don't eliminate defenses by talking your way out of open doors to viable defenses. Keep your mouth closed, protect your freedom, protect your future. You have to know your rights. We've talked about all these hypotheticals and all these textbook defenses to indecent exposure. Let's explore a real life case that my firm had where we were able to successfully defend at trial charges of indecent exposure against our client. And make no mistake about it, there was no situation here that it wasn't him and that he was framed or someone was making stuff up. This was an individual, for a number of reasons, who was masturbating in a public department store. He was on video masturbating in the department store. There was no defense to that. Our best defense was this was lewd conduct. It was not indecent exposure. Now you may be thinking, oh, there's a lawyer again, right? Legal talk, legalese, on a technicality, but that technicality was the law because the elements of indecent exposure require this individual, our client, to be directing attention to his genitalia when he was in fact masturbating so other people could see it. Without question, he was masturbating. Without question, he was masturbating in public. However, whenever someone would be in the aisle with him, he stopped doing that. So what was he not doing? What was the prosecutor unable to prove beyond a reasonable doubt? What was our best defense? Is that he wasn't doing anything to attract attention to himself, to another person, to sexually gratify them or him when they were around. And it was a very unique situation where we had to embrace how wrong this behavior was, how alarming this behavior was, but to literally look at it and say, no matter what you think about our client, the law is the law and it's there for a reason. And the jury responded well to that. He was convicted of lewd conduct in public, which is what we asked. And the jury hung 11-1 in favor of not guilty on the indecent exposure charge. That charge was eventually dismissed, and then he was sentenced accordingly on the lewd conduct charge. He did not have to register as a sex offender for the rest of his life. He was able to get the treatment he so desperately needed without lifetime consequences because his attorney and the team knew the law, we researched and did our work, and were prepared to defend him in court. short, not all hope is lost if you or a loved one are charged with indecent exposure. So what we've covered in this video, we've gone over the basics of indecent exposure law in California. We talked about Penal Code Section 314, what's required, what's not. We went through some lesser offenses or lesser related offenses of indecent exposure like lewd conduct in public. We talked about the possible penalties. First time for indecent exposure being a misdemeanor, several months in jail, a fine. And we talked about the biggest consequence whenever someone's charged with, and certainly when they're convicted of indecent exposure, that being Penal Code Section 290, sex offender registration, and for how long and how that law has changed and how indecent exposure as a misdemeanor is a tier 1 offense, which means you may be eligible to get off that obligation after 10 years of registration, but the first 10 years at the very least are mandatory and you need to be prepared to possibly register for the rest of your life. We talked about defenses. We talked about defenses related to the elements of the offense and how each and every element, just like any other crime in California, needs to be proven beyond a reasonable doubt. And arguably more important than any of that, we played out a real life experience, a real life trial that our firm handled, that I handled myself, where a client was charged with indecent exposure, where at first glance, it was one of those, wow, what are we gonna do with this? But when you dig into the law, when you dig into the facts, when you dig into the elements of the offense, you'll see that indecent exposure, although not popular, nor should it be, just like any other case, apply the facts to the law, work with what you have, work with the defenses you have under law to represent your clients the right way, to protect their freedom, to protect their future, to inform them of their rights. And now what we're asking more than any like, more than any comment on this YouTube video or on this YouTube channel is to share a video like this with someone you may know who might be going through a difficult situation, whether accused with indecent exposure or whether, quite frankly, accused with any sex crime or any offense like this that could lead to sex offender registration. So they know that not all hope is lost, and with the right attorney, the right team, the right facts, they could do anything and everything possible to regain some control of their future and put themselves in as good, if not a better position than they may have ever thought possible.